We should be worried because if lawfare that has been allowed to happen here, that's very much seems like it's unconstitutional and illegal. What about us, the small fish, regular Americanos? Well, right now we're standing by to listen to a case of regular Americanos, people who just minding their business, want to just live day to day and serve New York, do their job, be with their families, and live a peaceful life. 2020 took that away from many people. And this is why we're here. And this is why we're here. Because this has been an injustice that keeps happening, that keeps creeping up, that all of this is, all of this is connected. It has legs. And how many of you are liking the unfolding social credit system? Because that vaccine passport, maybe it temporarily went away in New York, but is it really away? You know, look at what entities are looking to pass things that will make it difficult to travel. It just doesn't make any sense. Again, if you're just tuning in, we are standing by to hopefully listen to this case today, Garvey versus the city of New York. It's been just demasiado de tiempo. These people needed to have had their jobs, and I pray that justice is on the side of the city workers, and that they get blessed and multiplied for all of their efforts and sacrifices. We just have no clue how many people have suffered greatly. For some people who acquiesced and so that they can keep their jobs, you know, that's very different than the people who said no for religious reasons, or no because they just didn't want to. And last I checked, we were still living in the United States of America. It just doesn't feel, it hasn't been feeling like that when they keep ushering in more rules and policies to just keep spying on regular Americans. Those people who support Trump get spied on. MAGA gets spied on. Can you imagine? I suspect that my sister and I, Cafecito Break, are on that list. Isn't that crazy? It just doesn't make any sense.
Okay, and attention to counsel. Case number 10, matter of Garvey against the City of New York, will be argued first.
Good morning, Your Honors, and may it please the Court. Amy McKenfield on behalf of the City Appellants. Your Honors, the decision below is an extreme outlier decision that casts doubt on the City's longstanding fundamental public health powers, and it misapplies basic principles of Article 78, administrative law, and constitutional law. This Court should reverse. At the outset, the Article 78 petition is time-barred because petitioners brought their petition more than 4 months after their February 2022 terminations. The two events that petitioners claim restarted the statute of limitations don't do anything of the sort. First, petitioners point to the mayor's March 2022 Executive Order 62. That had nothing to do with petitioners' terminations. The Executive Order 62 was part of the city winding down its Key to NYC vaccination program, and it slightly expanded the exemptions for the private sector employee vaccination requirement. It had nothing to do with petitioners' terminations pursuant to a collectively bargained agreement between their union and the city, and it had no effect on the municipal employee vaccination requirement. Petitioners also point to the letters that they received from the Department of Sanitation in June 2022 as allegedly restarting the statute of limitations. But all those letters did was notify petitioners that they were eligible to be rehired if they submitted proof of vaccination. And that's simply reiterating the policy that led to their terminations in the first place. And the cases that we cited in our brief show that subsequent termination that simply reiterates a prior agency determination does not restart the statute of limitations clock. So the Article 78 claims are time barred. But even aside from the time bar issue, Your Honors, the Article 78 claims fail on the merits because there was simply nothing irrational about the Department of Sanitation's decision to terminate these petitioners. First, as already noted, there was a collectively bargained agreement between petitioners' union and the city that specified in no uncertain terms that unvaccinated employees would be terminated, and the Department of Sanitation simply implemented that agreement. The underlying municipal employee vaccination requirement was also entirely rational. As courts have recognized, these kind of employee vaccination requirements easily withstand rational basis review. In fact, petitioners don't even challenge the fact that this requirement was rational when it was first issued. Instead, they argue that it became irrational over time, specifically with respect to the mayor's March 2022 Executive Order 62. But just as these subsequent events don't restart the statute of limitations clock, they don't provide a basis to challenge the rationality of prior decisions, specifically the municipal employee vaccination requirement and petitioners' February 2022 terminations. But in any event, even if we were to consider the mayor's Executive Order 62, along with the Health Commissioner's order that established the municipal employee vaccination requirement, even if we were to consider them all together, there's simply nothing irrational there. To begin with, there's nothing irrational with the government treating its own workforce slightly differently than it treats members of the broader public. And all we see here is two vaccination requirements that have slightly different timing and contours for municipal employees and private sector employees. Time and again, courts have affirmed that government has greater leeway in regulating its own workforce than regulating members of the public. And it was entirely rational for the city to prioritize vaccination of its own workforce to the extent that the municipal employee vaccination requirement was somewhat broader and in effect for somewhat longer than the private employee vaccination requirement. By prioritizing the city's own, by prioritizing vaccination of the city's own workforce, the city protected its workforce against COVID-19 and reduced the risk of transmission among city employees and between city employees and members of the public. And looking at the specific differences in timing and scope between the municipal employee vaccination requirement and the private sector employee vaccination requirement, all of those slight differences had a rational basis. So looking at timing, the municipal employee vaccination requirement was rolled out at the time that city employees were required to return to their offices or other work sites. So that made perfect sense. The private employee vaccination requirement was rolled out a month later in response to the Omicron variant and a COVID-19 surge. So expanding the vaccination requirement to encompass the private sector under those circumstances also made sense. The private sector requirement was rolled down before the municipal employee vaccination requirement was, and that also made sense because, again, there was no imperative for the private sector workers to be at their offices or work sites to the same degree that the city had that policy in place for its workforce. The differences in exemptions also made sense. So the private sector requirement always included an exemption for people that worked from home. At the time that these requirements were in effect, city workers were not allowed to work from home. So it didn't make sense to have such an exemption for the city workers. The private sector requirement also had an exemption always had an exemption for professional athletes and performers. And the city does not employ professional athletes or performers, so it wouldn't make any sense for the city to consider an exemption along those lines for its own workforce. So again, the mild differences in scope and timing between these two requirements all had a rational basis. So petitioner's Article 78 claim has no merit because the determinations were rational pursuant to the collectively bargained agreement, and the underlying municipal employee vaccination requirement was entirely rational. Petitioner's Boreali claim also has no merit. So to begin with, this court doesn't even need to apply a Boreali analysis. As the Court of Appeals recently clarified in the Stevens decision, Boreali only applies when an agency is acting under an exceedingly broad and nonspecific grant of authority. And here we have the administrative code that plainly delegates to the Department of Health and Mental Hygiene the authority to issue vaccination requirements. And when an agency makes choices within its appropriately delegated powers, simply makes policy choices within those delegated powers, that does not trigger a Boreali analysis. But even if this court were to apply a Boreali analysis, it's clear that petitioner's claim does not have, the Boreali analysis has no merit. Their claim has no merit because this court in the CF case and the Court of Appeals in the Garcia case have already applied Boreali to analogous vaccination requirements and found that those requirements withstood review under Boreali. And under those precedents, it's very clear that this vaccination requirement would also easily pass Boreali review. The same challenges that petitioners make about this requirement could have been said about the requirement at issue in Garcia. In Garcia, it was the requirement for city-regulated daycares to require that children attending the daycares obtain the flu vaccine. Now, certainly the flu could spread at settings outside of daycares, and certainly daycares that were not primarily regulated by the city could also be a vector for spreading the flu. But the Court of Appeals recognized that it made sense for the agency to tailor the vaccination requirement to something that was workable and practical and administrable, and that did not overstep under Boreali. Similarly here, it was entirely permissible for the agency to require municipal employee vaccination in the health commissioner's order. And last, Your Honor, one more point on Boreali. Another reason why petitioner's Boreali argument fails is because they're challenging the health commissioner's exercise of his authority, and the health commissioner was not directly responsible for petitioner's terminations. The health commissioner's order simply requires that unvaccinated workers be excluded from the workforce, and the health commissioner has that authority under the health code to exclude people from different settings for public health reasons. It was the petitioner's union that collectively bargained an agreement with the city. Under that agreement, unvaccinated workers would be terminated if they didn't have an exemption or a pending exemption request. And it was pursuant to that collectively bargained agreement that petitioners were terminated. So the health commissioner certainly has the authority to issue vaccination requirements. Indeed, petitioners concede that the health commissioner does have such authority in general terms. And the Department of Sanitation certainly had the authority to implement the collectively bargained agreement here. So for that reason as well, petitioner's claim that the health commissioner was acting outside of its authority fails. And last, Your Honor, petitioner's equal protection claim also has no merit. The applicable standard here is rational basis review because there's no suspect class, and it was entirely irrational for the city to require municipal employee vaccination. And again, to the extent that there were these mild differences in scope and timing between the municipal employee vaccination requirement and the private sector employee vaccination requirement, all of those differences themselves had a rational basis. And I would just note, Your Honors, that there have been many, many employee vaccination requirements implemented over the course of the COVID-19 pandemic. We're not aware of any other court that has credited an equal protection claim challenging such requirements. And this claim here also fails under equal protection review because there's a rational basis for the agency's action.
Thank you.
Thank you.
You may proceed.
May it please the court, again, Chad LaValia for respondents. The courts in this state have an unmatched record in advancing civil liberties. This case here today presents another opportunity for the court to do so. Except this case has one blind spot, and that blind spot is the fact that we all experience COVID and are influenced by it in some degree. But when that blind spot is removed, a picture of a mandate laden with social and economic policies, excessive power, arbitrariness, and class-based discrimination emerges. 16 sanitation workers were terminated because of non-compliance with the city's vaccine mandate. They were essential workers during the height of the pandemic, only to be discarded like trash when the pandemic began to subside. I'd like to take you through a roadmap of the arguments that we'll be focusing on here. First, under the separation of powers, the lower court correctly held that the mandate violated Article 3, Section 1 of the New York State Constitution. In regard to the first Boreali factor, once Eric Adams issued the Executive Order number 62 exempting professional athletes and performers, on the first factor, he was weighing public health objectives against the consequences associated with the loss of profits in interest groups like the National Basketball Association, Major League Baseball, National Hockey League, and the Women's National Basketball Association, as well as the entertainment industries, profit for private businesses, and even the morale of the city's residents. These are clear policy determinations, and that squares away directly with statewide, where the city tried to put a ban on the sugary cap drinks, but they prioritized profits of the beverage industry and also engaged in other policy considerations and financial concerns. It's the same exact thing here. So the city loses, and the lower court correctly held that the city loses on the first factor. The mayor limited the scope of the mandate quite literally based on financial considerations of special and business interests. This is not just a small difference, as the city contends. This is a very big difference. None of these are related to public health objectives whatsoever. They're pure policy considerations, and like in statewide, it also involves personal autonomy. And striking the proper balance among health concerns, costs, and privacy interests is a uniquely legislative function. And in Boreali, the health commissioner, the court reviewed the health commissioner's regulation there. So contrary to what the city is saying, is false, that they have pure authority to do whatever they want to. Boreali and his progeny stand for the very opposite premise. Secondly, they wrote on a clean slate because never before in history were these 16 sanitation workers required to get vaccinated as a condition of employment. It's entirely on a clean slate without any legislative guidance. City loses on the second Boreali factor. As far as the third, it evens out because there was no legislative action, and the lower court found that the Department of Health and Mental Hygiene did utilize expertise as to the last one. But overall, those factors properly militate in respondents' favor. As far as the Commissioner of Health's authority, the Commissioner of Health has absolutely no authority to exclude these sanitation workers from their workplace as a penalty for noncompliance. City Charter Section 558 limits the enforcement mechanisms to monetary or imprisonment, unless the legislature dictates otherwise. That's not what happened here. The health commissioner has no authority to either impose a penalty of not showing up to work or not being able to go to your workplace, or to impose a new condition of employment whatsoever, nor is the city even once cited to a provision of law that gives him such authority. So he violated his authority there. As far as the Equal Protection Clause claim, when Eric Adams issued that executive order, he created a tale of two cities where billionaires and millionaire athletes were placed above sanitation workers. He treated them differently with absolutely no rational basis. And what the city glaringly misses is that this was a public health outbreak of disease. It covered the entire city, the world. It covered the entire world. We have 8 million people that live in this city. And to say that these 16 sanitation workers were not similarly situated to other members of the workforce or other people is just patently false. And the United States Supreme Court in NFIB v. OSHA had stated very clearly that COVID-19 was not specific to the workplace. It was a threat present everywhere. And that was in striking down OSHA's attempt to impose a national workforce requirement for this vaccination. Here, it's the same thing. They're similarly situated to everybody else. And taking Jacobson versus Massachusetts, I think it shows a glaring contrast here. In Jacobson, there was an outbreak of smallpox in the city of Cambridge, Massachusetts. In the city of Cambridge, everyone that lived there, children and adults, had to get vaccinated. There were no carve-outs, there were no exemptions, but imagine if the government there said, we're going to exempt people in the city of Cambridge who make a lot of money. The Supreme Court would have struck it down. that's unconstitutional. Or if they made distinctions based on who the residents' employers were, whether they were employed or unemployed, that's arbitrary. Here, same thing. These 16 sanitation workers were ordered to be vaccinated simply because they worked for the city. Their employment status has nothing to do with stopping the spread of COVID-19. So therefore, it is not rationally related to furthering that public health objective. And then when you throw these carve-outs in from the executive order, it's even more irrationally related. It's even more arbitrary. And Mayor Adams did not try to hide the 8 ball here. He was very forthcoming and said it was for purely economic reasons. Had nothing to do with stopping the spread of COVID-19. And just to touch on Garcia again, this is not like Garcia. This case is just the opposite, and nor does it question the powers of the health commissioner or even the mayor in situations where there's a public health emergency. In Garcia specifically, the administrative code gives the board the power to add necessary additional provisions to the health code in order to most effectively prevent the spread of communicable disease. And so they added flu to the list of the health code. That's a direct legislative delegation of authority, whereas here, that does not exist. Now imagine if in Garcia, though, they decided to exempt children whose parents donated a lot of money to the city or whose parents made over $1 million. If they exempted those types of people, the court surely would have struck it down. And in CF, the Court of Appeals would have struck it down if in the Williamsburg area, when there was an outbreak of measles, specified to 4 different zip codes, if the health commissioner said, again, I'm going to exclude this group of people because they make more money than everybody else, the Court of Appeals would have struck it down. Same here. And further, going back to the equal protection, the city overlooks that, again, this was a public health emergency and it was an outbreak of disease. You can't just limit it to the workplace. And as far as their argument that this was somehow a condition of employment, Your Honors, that's patently false. In fact, in the record on page 334, there is a memorandum of agreement between the Sanitation Workers Union and the city. The first 2 paragraphs, the whereas paragraphs, say all city employees to be vaccinated by 10/29/21. And then whereas the parties desire to satisfy their bargaining obligations with regards to the processes and rules surrounding the implementation of the order, and their desire to reach an agreement regarding the process for requests for exemptions to the mandate. The mandate was already in place. The memorandum of agreement was just to implement the policies. But for that mandate, there would be no memorandum of agreement. Their union never accepted or collectively bargained for vaccination as a condition of employment, and is absent in the record entirely. As far as the statute of limitations, this was a hybrid Article 78 proceeding. So to any extent, the city's argument only would apply to the Article 78 portions, whereas the declaratory judgments would remain intact because this case was brought in July of 2022, which is well within the statute of limitations. Nevertheless, the 16 sanitation workers, they were terminated in June of 2022. Sure, they received a letter in February of 2022, but they also received a letter in on June 17th, 2022, saying that they could resume their positions as if they had never left with the same conditions and the same positions. All they had to do was the same thing they had to do in February, is to get vaccinated. And the case law is very clear on this with O'Brien and Martin v. Ronan, that an agency decision is not final if they haven't reached a definitive position on the issue, but more importantly, if the injury inflicted may not be prevented or ameliorated by further administrative action or steps available to the complaining party. Here we have both factors present. The complaining party, the injured party, the 16 sanitation workers, in June of 2022, if they were to get vaccinated, they could have ameliorated the injury of termination. Similarly, the agency was offering them to resume employment. So those two steps, they make it not final. It was not final in February, it was final in June. And while the city is going to talk about the memorandum of agreement, interestingly, in the memorandum of agreement, on the last page, I believe, it says that they have until June 30th to comply. It's not ironic, nor is it a coincidence, that on June 17th, when they received those letters, the date for them to comply was June 30th. The inference then is that the February letter was not controlling, and they were terminated in June. Either way, the agency's decision was not final until June. And therefore, the city's statute of limitations argument falls flat on its face. Alternatively, the injury didn't really present itself until March when Mayor Adams issued these carve-outs for professional athletes and performers. And regarding the city's argument trying to split hairs and semantics with the timing, first off, the argument about the rationale behind the private sector mandate, that was not made in the lower court. The city's making for the first time here today, and this court should ignore that. They waived it. Secondly, there was nothing in the record to explain why these mandates were being issued at different times amongst different people. Nevertheless, if the court were to look at it as separate pieces, it makes no sense. They were all implemented to stop the spread of COVID-19 within the city. Whether it was rolled out incrementally or not is irrelevant. They're all part of the same bigger picture. Secondly, Eric Adams' executive order number 62 directly amended the health commissioner's order on December 13th, specifically providing for the exemption of professional athletes and performers. That order also makes numerous references to what the city is calling the public sector order. Numerous ones, to each one, to the teachers, and then to the whole public sector. These are not independent pieces. They are one mandate working together. It is irrelevant whether the Commissioner of Health decided to roll it out to one part of a sector first and then another part of a sector later. It covered the entire workforce until it didn't. Because additionally, Mayor Adams didn't even enforce the private sector mandate. This was one collective mandate, and that's why they all reference each other, because they're all building up. It's like a chapter in a book, not separate books altogether. And also, just to bring the distinction to Garcia, in Garcia, the court correctly held that the flu vaccine requirement, it had no economic carve-outs or exemptions. It had no social policy built into it. It was a pure health objective, and anything that was put in further of it was not just incidental, it was directly to further those public health objectives. Here, it's specious for the city to say that exempting elite professional athletes and performers is rationally related to stopping the spread of COVID-19. It's not. It can never be. It turns all precedent right on its face and ignores what the mayor did. It's pure class-based discrimination. You're treating unvaccinated people that are similarly situated different without any reason other than they make more money. They bring in more money to the city. They're of a higher value. That does not fly under the Equal Protection Clause, and this court should not entertain that argument either. At the end of the day, the lower court correctly held that this mandate violated the separation of powers, at least the two first prongs of Boreali, that under Article 78, it was arbitrary and capricious for the same reasons it's not rationally related to furthering a public health objective under the Equal Protection Clause. Again, exempting professional athletes and performers does not further protecting the public health. Within these orders, the city acknowledges that this virus was present everywhere, and it had even a specific ability to spread in the workplace because of close proximity. There is no difference between a public workplace and a private workplace. They're still workplaces. So for Mayor Adams to make these exemptions, it's arbitrary. It has nothing to do with furthering the public health. Or even further and alternatively, breaking classes down into sections based on employment status is also arbitrary. Why? And the city was not able to make a record as to why they were treating unvaccinated sanitation workers different than unvaccinated private sector workers who were being treated different than unvaccinated professional athletes and performers. Nothing in the record. And because of that, they fail, Your Honors. And that's why the Article 78 stands as well. And finally, for all those reasons, this court should not reverse the lower court and should continue paving the way for the civil rights of individuals as it has done for centuries. These men and women are still not back at work over 2 years later, and they're asking for their day of justice today. Thank you.
Thank you very much. Number 2, please.
I have 2 just points I'd like to respond. The
We
corrected.
don't have rebuttal. If there's an error, just
Yes.
indicate the page.
Yes. Page 338 is the collective bargaining agreement. It specifies that benefits.
We'll
could be-
look at it. Anything else?
Page 23 of our reply brief is the Health Commissioner's authority.
Thank you.
Thank you for everyone that has been tuning in to listen to this case, Garvey versus the City of New York, where the judge ruled that the imposition of the COVID-19 Vaxx mandate and firing of city workers was unconstitutional. And we are praying today. Thank you for everyone who has been holding the space with us. This is what we do for the family, right? They have been with us, present in every single time that we went to court to support other city workers. And this is a big moment. Can you imagine, they sent out their media release, and this is a quote by Danny Hulkower, who's one of the plaintiffs. I just want to go back to throwing garbage in the rain. I almost want to cry thinking and contemplating that. I just want to go back to throwing garbage in the rain. Who the heck says that? Except someone who really loves their job, and they're doing it because they're doing it. And so much has happened to city workers and people who, it was not just city workers. Obviously, this is our focus today, but just people who were boots on the ground in all sorts of aspects of society in New York City. That also includes, freelancers, people in the arts. We haven't really covered that enough, and maybe I should, because those of us in the arts or freelance arts, that has gone very liberal too in New York City. And so people who were artists who didn't comply also got shafted. And we can't forget the people who worked in the restaurants and all of the people who, the freelancers all across the city, the teachers, the healthcare workers. There are thousands of people in New York City who said no and have different circumstances, but we have yet to see justice for them. You don't hear their stories, but a lot of them are still unable to get to find employment. Some people maybe spoke out, so they're not considered hireable, because it just doesn't look good to have certain people who were such big mouths out in the streets. I mean, if you don't believe me, I ask you to tune into the last Twitter space that we held, and you could find it on our Substack Cafecito Break, or you can find it on Cafecito Break Rumble channel. While we're here, I want to just remind you that we will be having a Twitter space today. Every Monday, 9 p.m., we're hosting the New York Stands Together town spaces.